Hi, this is Ed Sullivan and Marco Berti continuing our video podcast series on executive employment agreements. Mark, what are fee shifting provisions in employment contracts and how can they be useful to some executives or employers?
Well, fee shifting, Ed, as you know, is oftentimes under Texas law, the prevailing plaintiff in a contract action will win their fees. And a lot of times, even in a contract, it might say whoever wins, if there's a dispute under the contract, the other one has to pay their fees. Those aren't usual, and we see them all the time. What we see in some executive agreements, that's a very powerful thing, is a separate provision that says, executive, if I have to sue the company, regardless of the merits of my claim, and regardless of whether or not I prevail, company, you have to pay my attorney's fees.
Whoa.
And you have to pay them on a monthly basis. And I remember as a young lawyer many years ago representing a company in an executive dispute, and out of the blue I get a letter from opposing counsel saying, here's my bill for this month. And I'm wondering, why are you sending me your bill? And sure enough, I looked at the agreement and there it was. And you can imagine what that does to the settlement dynamics in a case when you have some high-priced executive lawyer representing the executive, sending their bills to the company. And so as an executive out there, now the law says if that's going to be the case, that clause needs to be crystal clear that that's exactly what it means. Otherwise, courts are pretty loath to interpret a clause that's vague in that fashion because it's so contrary to how we normally do business. But if you're an executive out there and a company really wants you, you'd be well served to hire good executive counsel and try to get one of those clauses in your agreement because it's a powerful tool.